He's
But
the father. Child who was
He is
driving.
the father. The child was driving. The father had given a driver also.
Other
All of the
man,
parents.
one more was there.
Everything.
No, everybody is gone.
No, my lord.
He's the last.
If I may clarify, the last matter which was disposed of, what was contended.
The doctor.
No, they were also the fathers, but what was contended was just a second, sir.
No, the last one was the
The
doctor.
last one was the
Was the
doctor, but
doctor.
Mr. Ashish Mittal and Mr. Aditya Sood, the contention was that look here, our children were sitting at the back. They are neither an accused, they are mere witnesses. This may be distinguishable because the petitioner here is the father of the child who was driving the car.
So
What is the
There are
father?
yes, my lord. Then in that case, see my lord, he is the one who calls for cash of 5 lakhs,
please.
tells the wife, you take this 5 lakh, go give it to the doctor, swap your blood samples with the sample of the child in conflict. I have annexed those statements, my lord, with my counter. If your lordships may have my counter for a moment.
Inside.
Page 43.
22 months, my lord.
Very well, the witnesses
22
are
months
their employees. my lord.
And my lord, prosecution record that I had given a driver. My lord, the child, my lord.
We don't know about that.
No, it's recorded. I am saying an admitted position.
Driving for whether.
No, I am not saying that. Say child was driving, but I had provided a driver, my lord. Beyond that, what can a father do, my lord? He had provided a driver.
My lord, may see
It is
page
recorded
44.
that the driver was there.
My lord, ask me about the role of this accused. My lord, may see page
22
44 of
months
my
have gone by
counter.
in a car case.
Page 43 of my counter for a minute. This is Manish Suresh Verma, who is a witness. May I read page 44 for a moment of the counter filed?
How long you want to keep it inside?
For what?
Millard, at least,
At least what?
Millard, at least till these witnesses who are their employees, are examined,
Millard,
they
fair.
go to the High Court and take a stay that charges will not be framed. They refuse to argue for charge before the trial court.
I have not taken any stay from any court, my lord.
Ashish Mittal, I showed that
I
at the
finished
last
my
occasion.
argument, my lord. The wife was granted bail. Father, my lord, is...
Petitioner has taken any interim order?
Millard,
No.
Millard may see page 76. Millard may see page, I have annexed that order of the counter, Millard. I have annexed that order of the High Court.
Order of the High Court.
Who's got bail?
High Court, where the High Court has ordered deferment of the charges.
See, my lord, page 77.
Mr. Ashish
Civil file, it is
Mittal,
by
Mr.
Mittal.
Ashish Mittal, who was on the last occasion which was argued, it was said,
But Mittal has got bail from, my lord.
no, Millard. Therefore, since it is all of them are being tried, the endeavor, Millard, again is to show that the delay in trial is not at my instance.
Mittal has got bail, my lord, from your lordship.
Millard, what was argued last time was that, look here, Mittal sir is not driving.
Yeah, what we can see, people are driving.
Therefore, Millard may see page 44. Yes.
It did happen.
No, Millard, the distinction I am trying to make is
Lord,
what
these
was
are not
argued.
premeditated
Just a minute, sir.
cases.
What was
These are
argued on
cases
the last
That
instance
kind,
was,
my lord. Sorry.
Millard, when the bail applications of Ashish Mittal and Sood were being argued, the ground was that, look, our children were sitting at the back. They are witnesses, they are not an accused. Therefore, why should we be not released on bail? Millard, my argument is that that sense of parity will not apply to this accused, this petitioner, especially in view of page 44 of my counter. Millard, may just see it for a moment.
The son. Huh?
The child who was driving is admittedly the son of the petitioner. He was in an inebriated
That's
state. He's taken to Sassoon Hospital to get his blood samples taken. And Millard may see page 43. This is the statement of one Mr. Manish Suresh Verma. He's the driver of the petitioner. At para 2, he says, I work as a driver for Vishal Agarwal. Then Millard may see page 44, para 2. When I met Vishal Agarwal at Yerawada police station, he told me that Vedant, who is the child Millard, had been involved in an accident in which 2 people had died. He said we needed to go to Sassoon Hospital. He told me to park my motorcycle there and travel with him in his car. At that time, I accompanied Vishal Agarwal to Sassoon Hospital in a Kia, driving around 10:15 a.m. From there, we all waited at ward number 40 of Sassoon Hospital. Vishal Agarwal's friends were also present there. Later, at 11 a.m., Vishal Agarwal asked me to call Shivani Agarwal, who's the wife, Millard, and tell her to bring 5 lakh rupees. I immediately called her and informed her. After about 45 minutes, Shivani Agarwal arrived at Sassoon ward number 40 with 4 lakh rupees. Thereafter, Shivani handed me 4 lakh and instructed me to give this amount to Ashfaq Makandar and Amar Gaikwad, saying that Rajiv Gupta would accompany me to the police station. Shortly after, Vishal and Shivani left. Surendra Agarwal took rupees 10,000 from the amount given to me by Shivani Agarwal. Then I and Rajiv Gupta, a relative of Vishal Agarwal, reached Yerawada police station by 2 p.m. in a Kia car bearing registration number so-and-so. During this time, Surendra Agarwal also arrived at Yerawada. While I was at the Yerawada police station, Roshan, who boy works as a domestic helper at Vishal Agarwal's bungalow, brought me rupees 2 lakhs. Shortly after, Rajiv Gupta instructed me to give rupees 4 lakh to Ashfaq Makandar, who is at the hospital Millet where the blood is swapped with the mother. At that time, Akash Makandar was present at Yerawada police station. When he approached me, I gave him rupees 4 lakh as instructed by Rajiv Gupta. I don't remember the exact time, but it must have been around 2:30 p.m. After that, we all reached the Juvenile Justice Board so-and-so. Then let me see page 50, who is a family friend of this Vishal Agarwal.
My lord, they are all on bail. All the
Very well,
persons who have been mentioned here are on
Page
bail.
50, my lord. So this petitioner calls for the money,
This is 160.
sends the money to for the blood samples to be swapped. Very well. All I'm saying is that these witnesses were in his employment. At least they can be
Why should
examined
they
and
be-
then his bail may be considered.
This is not fair.
I am not saying it is proof, Millard. All I am saying, Millard,
It's a 161 statement and those persons are on bail.
Millard, there is a
The ones who are
164
mentioned.
also. There is a 164 of this. I have annexed it, Millard. Page 46 is 164.
Right, they are
Yes.
suspended and fine.
No, Millard.
No.
My learned senior appears.
They were just students, the two of them.
They were friends.
Graduated and they were friends. They were riding on the bike. I appear for the father of the girl who was killed in the accident. I have a few submissions.
Have you made any motor vehicle accident claim? Have you made a road traffic accident claim?
That I'll check. I'm not sure.
Claim has been made, which is paid.
But I'll get.
We have
But
offered
if
Your
I'm-
car was insured? Was your car insured? Your car was insured?
The registration plates were removed.
Yes.
There were no registration plates. If I can, I just want to make a few sub.
Car number is identified.
There's no dispute about.
There's no dispute about that.
I'm looking at that
I'm not
on the
disputing.
counter. Can I just?
Father, why should I dispute?
For any road traffic accident.
Correct.
Whether it is an injury or death,
Correct.
fatal, it is unfortunate.
Correct.
In this case also it has happened.
Can I just make a submission in that regard? I know I've heard what your lordship said.
As for MACT,
Can I just make a submission, if I may? There are thousands of road accidents that happen in this country every day. Many of them involve intoxicated drivers. Many of them involve minors. And in any one of those, for us to stand and oppose bail would, I think, be churlish. 999 out of 1,000. Occasionally, this court is presented with cases where it is not, I'm saying this repeatedly, it is not about the accident and the death of the child. It is of subverting the cause of justice, that this court is awakened to the fact that there are charges here under 467 which go up to life imprisonment. Now, if I may just mention, immediately after the incident, there are a series of phone calls made by this man as the ringleader of a conspiracy who decides, I'm going to do the following things. I am going to, after the incident where the son is involved, after that, I am first going to have blood sample substitution made. I am going to delay blood sample taking. I am going to bribe doctors. I am going to ensure
punishment for the.
life, 467 life.
What?
Yes.
Life for what?
Yes. Under the 467 charge.
What
This
467?
is not a debate.
There is no 466.
Yes.
How can there be 467?
Yes.
Negligence caused the juvenile. What is his maximum?
Juvenile is not here. So that is for the 3 years. 3 years. 3 years. 3 years.
3 years.
For the juvenile is 3 years.
3 years.
For the juvenile is 3. So that's why I'm sorry. Just 1 minute. I just allow me to just complete.
Driving.
Can I just complete? The driver says that he coerced me to take the onus on myself. Now, please note, my lord, this has happened as your. There's a separate FIR registered on that. Subverting
So,
bribery, corruption, subverting the cause of justice, I'm hoping will be different from just a mere drunk driving incident. Now, if you are defrauding the judiciary and thereby the victims,
convict them. Get them convicted.
Yes, absolutely.
Get them convicted.
now the forgery of the court record, the charge under 466 is for 7 years. Now, each of these sets this man in a unique position as against even the fathers of the other children, etc. The CDR show that from 2:30 a.m. phone calls were on. He is asked, he's given 4 lakhs, he gives to his minions to go and bribe doctors.
Actions against him.
Yes,
From getting them proved and getting.
nothing. But the problem now is, so I'll just, the grounds for bail classically is that you are not going to coerce material witnesses. that there is a statement by the material witness that I have been coerced. The material witness has registered an FIR that I have been coerced.
Then later on,
No. So the bail has not been granted yet. So I don't have to ask for cancellation unless your lordships grant bail.
to say
Yes.
that there are certain conditions,
Yes.
the violation of which would result in.
No, he's already violated it before, which is why bail should not be granted. Plus 1 minute, just 1 minute, one more.
State
No, it's ready for trial.
Charge sheet has been.
It's ready for trial. Now, what has happened is this. There are 4 CCTV camera records which have been shared with the accused. Accused says in the hospital premises, there are 21 other CCTV cameras. 50 other CCTV cameras. I want those records. Until I get those records, I want your lordships to stay. The charges have been therefore postponed. The trial has been stayed on that count and that count alone. That has been done fairly at the behest of a co-accused. Now, if the conspiracy question is true, because phone calls were made between all these parents, then our man doesn't have to file the petition himself to get the charges stayed. He tells the father of the other person, you file it, but gets a benefit of it. So right now we are in a situation where the
stage of the, where the, to hear before charges are framed is
We
happening.
have finished our arguments.
No, the High
Without
Court.
one other person went to the High Court asking for record about this CCTV. The High Court has deferred the trial. He is now putting that to me by saying that I made a phone call. Without any father will make a phone call at 3 o'clock in the morning to his friend if his beloved son goes into an accident.
But the
So what
statement is that the
what
father sends money.
Is it
Father
a
sends money.
Forms? What
Milord,
what
we
argument
paid
is being
74.
made here?
The High Court says, please renew your bail application after the material witnesses are examined. Now, for a man, apart from the suborning of witnesses, he absconded. He was arrested. This happened in Pune. He's arrested in Aurangabad. He doesn't come and surrender. It's his car, his son. He doesn't surrender. He's arrested 2 days later in Aurangabad where he is on the run. Now, I'm just saying that if there is this compounded misconduct by a person, please, my lords, don't reduce this to a small issue of saying there's a child at the wheels of a car who's drunk. We're not on the child. We're not on his drinking. We're not on the accident. My daughter is lost. She's lost. But the question is, can the judiciary be okay with itself being...
What is this?
Say that,
Yes.
we want to say
Yes, ma'am.
that whatever you're saying,
Yes.
a reflection of the mindset of the Indian society. This is how everything happens.
Yes.
Otherwise, why do we have so many matters? If everybody is straightforward, everybody wants to get the better of the law. If they are to face the law as it is, all this will not happen.
No, it is not.
Now, the question is, this is the mindset of the Indian society. If this is the mindset of the Indian society, under the set conditions, whether the question is a man has to lose his liberty until he is convicted, therefore there should be a punishment before conviction, he may be acquitted also, or the man should have his liberty. That is the question now for us.
When the charges are this serious...
Society
Yes.
is, if you have to ask me, I must say it is backward because we have not learned.
100%. But a strong message needs to be sent to make them learn.
That is not at the cost of a man losing his liberty.
No, but they can't get away with thinking they can corrupt every institution.
Getting away.
You can't corrupt every institution and think you'll get bail.
Issue.
That is not the question. What is our educational institutions doing? What are they doing? If this is what everybody thinks, the citizenship, values of the constitution, how to face the law, be straightforward is not taught to our children.
Not
They
taught.
will grow up to be like this.
That is true.
It is so symptomatic.
Milord, may I-
That's true.
What to say about it?
So this is why this is a case where that message can be sent.
Oh, I'm sorry. It's not as if you have come from another world or another society.
If everybody is to cooperate with the law, they don't even stand in a queue before entering a lift.
No, I agree.
Then
I agree.
what have we done for 75 years? Constitutionalism. Please tell us. Values of the constitution, self-rule, independence, freedom, to live a constructive citizenship. All this is
But
what
who else will lead the way, my lords, apart from this institution for these values?
can't be imposed.
We've seen what they've done.
Deny liberty to a person. See, it can't be. Why is it that if in every case you start denying bail,
This is not every case. This is why it's a unique case, my lords. Huh.
Why persons are coming right up to the Supreme Court for bail? Tell us that.
No, but in these kind of cases, it should not be entertained.
Not anybody to repair the society like this unless our teachers, our leaders, whoever it is, they go into the right direction. Otherwise, these are all symptoms which are there in the society. But why is it that when they come right up to the Supreme Court, we grant bail? It's all right, we can say trial court has denied, high court has denied. We will also deny because
There are some cases in which your lordships will deny bail. Some befitting cases where you will deny bail.
sometimes reason.
Bye. WhatsApp messages, your lordships have denied bail. This is so much more serious. 50 times more serious than that.
You conduct the trial and
Milord, we are not. That's what I wanted to show, Milord. This coterie of accused, they say give us 50 cameras where they are not even required, and then they go to the High Court.
appellant or petitioner responsible for the delay.
Ringleader.
Milord,
Number one.
the allegation is that he is the leader.
Phrases are being used. Milord, what kind
Not
of
about the
phrases
car
are being
accident.
Is
This
it a
is about
conspiracy
subverting
to commit a murder?
justice and a strong message. Exactly the values your ladyship mentioned can be instilled only if strong messages are
Some
sent.
message should be to grant bail.
Strong
After
messages
22 months.
that your deep pockets will not get you bail.
And
That's the
Milord,
message.
one more point. This whole Milord, if I may just show one more page, this statement which I just read out of sending 5 lakh rupees, it has not resulted in nothing, Milord. There is a DNA report which conclusively shows that. No, Milord. And again, no. The point is that this whole story about the trial being delayed is attributable solely to these petitioners, Milord.
Trial
We are now under.
Milord, now there is an order of the High Court.
grant of
Very well.
2 Sessions Court.
No, at least on the victim's behalf, can the trial be expedited then? I have no other avenue.
They should
Yes,
challenge that order.
let that be done.
They want to.
Let that be done.
They challenge that order.
State should have come.
Cooperate.
Absolutely.
No, cooperation. Yeah, there's no question.
Delay, we can write that.
Without your lordship, my record, I have not filed
The
any.
trial-
I will not file any.
Let the trial be expedited is all I'm saying.
Yes, we can.
Yes, that's
Constructive argument.
that is. All of those were constructive arguments. I'm sorry. I said this is an exceptional case. There are some cases, however harsh they are, where Article 21, while pressed into service, will have some limitation. Some cases. This is one of them.
Yes.
Yeah.
Leave granted. Learned Senior Counsel appearing for the appellant submitted that the appellant herein is the father of the minor boy who was driving the driving the car on the fateful day. He was driving, no?
Yes.
They.
He was driving.
Milord, that's the allegation that he,
Despite a driver being provided
available, Milord. Yeah, that's the allegation.
that the allegations which have been leveled as against the appellant herein are not true at all. That in respect of that, with regard to the other accused, this court has granted the relief of bail. The appellant herein is also similarly situated, inasmuch as he has also completed 22 months of incarceration. In the circumstances, the appellant herein also may be granted the relief of bail, subject to the terms and conditions to be imposed.
May I be excused?
God, the orders passed by this court in the connected appeals have been brought to our notice. You give us the copies of that.
Yes.
Per contra, learned standing counsel for the first respondent, even he is a party. Are there parties in this?
No, Milord.
Mr. Gopal
They
Chakra.
filed an application for
Your
intervention.
parties in the High Court. So that's
Per contra, learned standing counsel for the first respondent, for the respondent state, with reference to his counter affidavit, contended that the allegations against the appellant herein are serious, that there is no parity between this accused, the appellant accused, and the accused in the other cases wherein this court has granted the relief of bail, inasmuch as the appellant herein is the father of the child who was at the wheel, who drove the vehicle on the fateful day leading to the death of two innocent persons on the road. He contended that attempts were made by the appellant and the other accused to ensure that the evidence in the instant case is not only suppressed but also is substituted only in as much as the attempts were made to substitute the blood samples of the appellant's son and the other and his friends who are sitting in the back seat of the car. The allegations being serious as against the appellant herein, this court may not grant the relief as sought for by the appellant, as it would jeopardize and frustrate the investigation as well as the trial. In the circumstances, learned standing counsel for the respondent contended that there is no merit to this appeal and the same may be dismissed. We have considered the arguments advanced at the bar in light of the material on record as well as the fact that in similar cases, this court has already granted the relief of bail to the other co-accused. The orders in the connected matters are dated so and so. You just say that, huh? We also note that the appellant herein has been in jail for the last 22 months.
22 months, below.
The circumstances, we find that the appellant has made out a case for bail. So let him be produced before the concerned trial court as early as possible. We shall extend and released on bail subject to the conditions to be imposed.
Some other conditions were imposed.
Complete cooperation in the investigation of the case.
In the trial, below. Now it's, there's no investigation.
So much hard-
Yes, it's only trial now.
All right. The trial of the instant case, he shall not misuse his liberty in any manner. He shall not make any attempt to contact the witnesses either directly or indirectly. Any infraction of the condition shall entail cancellation of the bail granted to the appellant. Having regard to the facts and circumstances of this case, we direct that the appellant shall in no way cause any frustration or delay
In the trial. Yes.
We also direct the concerned trial court to endeavor to conclude the trial at the earliest. And within what time you can prosecute them?
Expeditiously, your lord.
Lordship will say expeditiously because charge has to be.
There is a stay on framing of charge, Millard, by the High Court. There is a stay on.
We can't say anything now. They are entitled.
Therefore, Millard,
See,
very well, very well.
Every accused has a right to seek discharge.
What
to
should
seek
we do?
forfeiture of-
I am not submitting anything, Millard. I am not making any submission on that.
Everything should be under.
Your Lordship will say expeditiously, below because discharge this, that. Grateful.
conclude the proceedings at the earliest.
Yes.
Appeal is.
And Millard, liberty to the state in case any violation.
That is there.
Yes, further, we have written that any infraction of the conditions shall entail, may entail, not shall, we have said you do it there, may entail in cancellation of the bail granted to the appellant. Yeah.
Great.
Oblige me.